trying to bring me down. Enemies lurking, but I won't back away. Got a vision in my mind, I'm here to stay. Got my crew beside me, we rise like a tide. When the storm gets rough, we ain't gonna hide. Propaganda swirling, but it won't touch me. Only love around, that's how it's gonna be. Keep moving forward, never looking back. The truth's in the power, it's an unstoppable track. In the city lights where dreams collide, we hustle through the night, fire in our stride. Whispers in the dark can't dim my glow. With rhythm in my soul, I'm ready for the show. We break the chains, rewrite the rules. In this concrete jungle where nobody's fools. Unity sings louder than the lies they scheme. In the heart of the struggle, we dare to dream. Keep moving forward, never looking back. The truth's in the power, it's an unstoppable track.
Another Queen Amadaya production.
Haze on the corner, they talking real loud. Spreading no light, trying to bring me down. Enemies lurking, but I won't back away. Got a vision in my mind, I'm here to stay. Got my crew beside me, we rise like a tide. When the storm gets rough, we ain't gonna hide. Propaganda swirling, but it won't touch me. Only love around, that's how it's gonna be. Keep moving forward, never looking back. The truth's in the power, it's an unstoppable track. In the city lights where dreams collide, we hustle through the night, fire in our stride. Whispers in the dark can't dim my glow. With rhythm in my soul, I'm ready for the show. We break the chains, rewrite the rules. In this concrete jungle where nobody's fools. Unity sings louder than the lies they scheme. In the heart of the struggle, we dare to dream. Keep moving forward, never looking back. The truth's in the power, it's an unstoppable track. Haze on the corner, they talking real loud. Spreading no light, trying to bring me down. Enemies lurking, but I won't back away. Got a vision in my mind, I'm here to stay. Got my crew beside me, we rise like a tide. When the storm gets rough, we ain't gonna hide. Propaganda swirling, but it won't touch me. Only love around, that's how it's gonna be. Keep moving forward, never looking back. The truth's in the power, it's an unstoppable track. In the city lights where dreams collide, we hustle through the night, fire in our stride. Whispers in the dark can't dim my glow. With rhythm in my soul, I'm ready for the show. We break the chains, rewrite the rules. In this concrete jungle where nobody's fools. Unity sings louder than the lies they scheme. In the heart of the struggle, we dare to dream.
All right. Hello, everyone. Thanks for tuning back in once again to the original Queen Amadaya-Shakur show. I'm your host, Queen Amadaya-Shakur, and this is your Sunday Vitamins. So as you're coming in, please feel free to go ahead and subscribe to the channel. If you haven't done so already, be sure to click that notification bell and click the word all so you're notified each time the Queen Goddess goes live. Okay, put a 1 in the chat if you can hear me loud and clear. Please put a 1 in the chat if you can hear the Queen loud and clear. And while you're putting the ones in the chat, or not, I'm going to go ahead and have a brief word from my sponsor at 12 Tribes. All right, once in the chat if the audio is crisp and clear. Thank you.
Do not buy 12 Tribes on Earth hair growth oil and hair magic elixir unless you want super healthy, gorgeous hair that grows. They have a whole line of amazing hair growth products, including hair growth leave-in conditioner spray, hair growth shampoo, hair growth spray, and hair growth butter. I'm starting to sense a theme here. They include quality natural ingredients. They smell amazing, and you can see the results for yourself. So if you're looking for healthy hair growth for your natural or relaxed hair, try 12 Tribes on Earth today.
Okay, so don't forget you can purchase 12 Tribes hair oil at Etsy.com. Just look for Lisa Crafts. And you can also find it at Walmart.com. With that all being said, shout out to all of the fathers. I hope you had a wonderful and blessed Father's Day today. Okay, and so let's get into it because, listen, it's already past my bedtime. Y'all know I have to be up at 4 o'clock in the morning. Okay, so I'm going to go through this. Now, Diddy has filed to keep juror number 6. And in fact, they're saying that if they're going to take out juror number 6, because they're saying that this is all based on racism, and basically they're going to be filing for another motion for mistrial unless juror number 6 is allowed to stay. Okay, so I have the legal docs here, and this is breaking news. I'm going to share my screen so you all can see this. Likes up, everyone. Please be sure to like the video. It's very important that you like the video. Okay, that helps us in the algorithm. All right, so let's get into it. Now, there are a lot of things that are, in fact, hold on for just a second. There are some things that are, in fact, redacted in this document. Hold on just a second. Let me put my watermark on here. Okay, there we go. Okay, so let's talk about it. Let's talk about it. Adrian said, I thought juror number 6 was gone already. Well, the judge did say that he was dismissed, but he also said, beloveds, after the attorneys for the defense made their arguments on Friday when we were held over in court, the judge said that he would think about it over the weekend. So there's a possibility that he may change his mind. He did say that he would give it some more thought over the weekend. Okay, but as for now, he's dismissed. Okay, so let's get into these documents and see what's going on here. Now, this was filed today. Okay, dear Judge Subramanian, the defense submits this letter in further support of its vigorous opposition to striking juror, and they're not saying the number, but we know it's number 6, a Black man. Mr. Combs would be substantially prejudiced by the dismissal of this juror, and because there is no factual basis to remove him under Fazio, the court lacks discretion to do so. Moreover, if the supposed inconsistencies in his answers to the court's questions were truly of concern, and as you can see, that next part is redacted. It says, if the court strikes juror number 6, I'm just going to go ahead and say it. We respectfully request that a mistrial be declared. Okay, are y'all listening? Do y'all hear this? We understand that the court has refused to find any discriminatory motive in the government's actions with respect to its preemptory strikes or this motion. However, we respectfully and regrettably disagree. The government's motion must be evaluated in light of the entire history of this investigation and prosecution, and not in isolation. Unfortunately, when considered against that background, it is impossible to believe that this motion is merely a good faith attempt to raise a valid question about the juror's integrity, rather than an effort to make or to take advantage of an opportunity to strike yet another Black male from the jury. Now, they say in point A, there is no valid basis to dismiss this juror. Now, some people might beg to differ, but here's the thing. I just feel like if they wanted to strike this juror, if they felt like there were inconsistencies, that this all should have done during the process of voir dire. Okay, this should have done when they were in fact striking people. Why would you wait 5 weeks into a trial and then they say that someone from the jury department said that this man told them that he lived in New Jersey? Well, that's hearsay. Does this person who claims this, do they have a recording? Do they have any audio? Do they have a third party who witnessed the conversation? I just have questions, because if not, it's his word against the jurors. And also, the defense brought up a good point. They said, why not? And this is what Xavier Donaldson specifically said. Why don't you allow this man to come in here and speak and explain himself? Well, I think that that's fair. Okay, I think that that's fair. So, Nicole said, Queen, it's time for you to come back. Okay, Lewis said, Queen, are you going to speak on the Minneapolis mishaps? Not today, beloved. I don't have time for it tonight, and I don't have all the information on that, beloved. Someone just informed me about that today. Okay, so I'll get the information, and maybe I'll talk about that in the morning while I'm waiting in line to get inside the court. Okay, when I go live then. All right, so right now I want to talk about this, and I don't want to be on here long because, like I said, it's past my bedtime. Okay, so with that all being said, they say, first, there is no question Mr. Combs would be severely prejudiced if the juror in question were removed and replaced by the first alternate. We have previously pointed out that this juror is one of the only 2 Black men on the jury, but it should also be noted that he is the juror who is perhaps most similar to Mr. Combs in other important ways. He is a black man, and this part is redacted. Moreover, this case involves serious charges of sexual misconduct against women who were in relationships with Mr. Combs. Now, as the opening statements and the witness testimony have revealed, the principal dispute between the parties is whether Cassie Ventura and Jane willingly participated in the sexual activity at issue during their relationship with Mr. Combs for their own reasons and because they chose to do so, or whether, as the government claims, they were coerced. Now, the fairness of the trial depends in part on having jurors with backgrounds similar to Mr. Combs's to share their perspectives on the evidence with other jurors from diverse backgrounds during deliberations. Removing this particular juror will deprive Mr. Combs of that important perspective, and it is no answer to simply say that there are other black jurors or other male jurors on the jury. Now, second, there is no factual support for the government's position or, respectfully, the court's statements Friday afternoon, which were in stark conflict with the court's apparent mission Friday morning. Because here's the thing. Now, prior to, when they first were talking about this on Friday morning, the judge said that he had no intention of getting rid of this juror. He literally said that he was not going to get rid of this man, that he was not going to dismiss this juror. Now, whatever happened between that morning and the evening before we left, that made him change his mind. That I find that very interesting because he seemed pretty adamant that he was not, in fact, going to dismiss this juror. Now, I want you to remember, because when they gave the arguments, the defense that is, of why this person should not be stricken from the jury, Brian Steele stood up and said that it was because the prosecution was upset about his facial expressions and that they now want him to be dismissed. Okay? So, with that all being said, I find that very interesting because someone did a video talking about the facial expressions of the jurors. Okay, now, with that all being said, they go on to say which were in stark conflict with the court's apparent recognition Friday morning that the purported inconsistencies were likely completely benign. Okay? Now, as we explained at length in our letter of June 12th on this topic, there were no material inconsistencies with respect to anything juror number 6 said during the year and in the June 9th colloquies. Now, I want you all to pay attention because here's the thing I find interesting. I told you all that some of these people came in there, specifically, let's talk about it. Brianna Bogalov came in there telling falsehoods, okay? Came in there telling falsehoods, and that was okay. But now they want to act like this man. Nellie said it's like they are bullying the judge. No, I don't think they're well, the prosecution, I wouldn't say they're bullying the judge. I just think that the judge is giving more credence to what they have to say. But that's just my opinion. That's just my opinion, beloveds. But anyway, let's continue. Okay, so hold on, where was I? Okay, so there were no material inconsistencies with respect to anything juror number 6 said during voir dire and in the June 9th colloquies. And the juror's willingness to perform this public service and his civic duty should be considered a positive rather than a negative factor. There is no evidence whatsoever that he had an agenda or a bias in favor of either party, and no legitimate reason to jump to that conclusion. Well, here's the thing that I find interesting. What if, in fact, the juror did have in his mind one or the other, whether he's for the defense or the prosecution? Isn't it, in fact, up to jurors to decide whom they believe, whose side is more convincing or has a more compelling argument, and therefore they base their decision off of that as well as the evidence presented? I mean, I don't understand why someone would be upset because they think that a juror is not leaning in their favor. Does the juror have to lean in the prosecution's favor? I mean, I just have several questions because I thought that jurors make up their mind based on what they see and hear in the courtroom by way of evidence and testimony and the arguments presented by the attorneys. Isn't that how this is supposed to go? So you mean to tell me if a juror's not saying what you want to hear, or they're not looking the way you want them to look, or you think that they're going a different way, that you just get to try to get that person dismissed? I find that very interesting, and that doesn't sound ethical in my opinion. But hey, what do I know? Now, I'm not on Team Diddy at all by no stretch of the imagination, but at the end of the day, I do think that justice should be unbiased. Okay? But let's continue. So, anyway, it goes on to say, and the juror's willingness to perform this public service and his civic duty should be considered a positive rather than a negative factor. There's no evidence whatsoever that he had an agenda or a bias in favor of either party, and no legitimate reason to jump to that conclusion. Indeed, the court had an opportunity to assess the juror's demeanor, not only during voir dire, but also at closer proximity in the robing room during the two colloquies on June 9th. Now, the court never suggested at that time or at any time before Friday afternoon that it had any reason to doubt that the juror was doing his best to be forthright and honest with the court. During Friday morning session, after having reviewed both party submissions, including the government's lengthy quotes from the relevant transcripts, the court indicated it was inclined to agree that there was an insufficient basis to find that the juror was being deceitful and intentionally so, as the government charged. Here's the thing. I told you all, to me, this man wasn't being deceptive. To me, he was being transparent, okay, because he didn't have to tell them anything about New Jersey. Now, where is he paying taxes? Where is he registered to vote? What is the address on his driver's license? Okay. And so the defense's submission is really that the answers given, the nature of the inquiry, both in jury selection and during the current process, was vague enough so that the answers could easily be reconciled with each other. And the subject matter of what was being addressed is so far afield from the juror's performance of duties that that's not a reason to remove the juror. The real suggestion from the government as to the reason why the juror should be removed is because if you take the inference against the juror's credibility, there is a view that answers and the was being deceitful and intentionally so, either in jury selection or in the colloquy in the robing room, then that would be grounds to disqualify the juror. Okay? Now, with that all been said, for that to happen, we would need to have a further inquiry with the juror. And that's what they suggested on Friday, that rather than just simply dismiss this man without giving him so much as a chance to speak for himself, they said that's just not right. They should at least allow him to speak his piece or to explain or to answer any questions that they may have. That's what makes it all seem sketchy, because you don't even want to allow the man to come in and speak for himself. So, because on the current record, there's an insufficient basis to make this determination. And in terms of how we view the inquiry post jury selection, I think that there's a difference. I think that when we address these types of questions during the jury selection process, there may be an inkling or a suggestion that there's a reason to disqualify a juror for cause. And that has one standard, but it's before the exercise of preemptory challenges and impaneling of the jury. And so that has one standard. I think the defense's suggestion, and I think it's consistent with a lot of the cases, is that default actually flips once you have the jury actually in the box and you have a regular jury and alternates. At that point, you need something more to disqualify a juror. And the cases cited by both sides have situations presented that are far more extreme than what's being presented here. Okay, because this seems so minuscule, is what they're saying. Like, at the end of the day, this is not something that is absolutely problematic. This is not a big to do. And this is something that absolutely is not that serious that it would warrant the man being dismissed, is basically what they're saying. Moreover, although the court indicated a preference for further inquiry, it specifically noted that and this is the quote, I think that it is likely that what we will hear will be a perfectly innocent explanation for the answers. I don't think that they're irreconcilable. I think that for the reasons that the defense has stated, there's a way to reconcile the entire record. Now, the court also noted that the only reason why this situation even came up is because of a statement that was made on the juror's own volition to jury department staff in a friendly and in an offhand banter. The court further observed and says, and there's perhaps an understandable way to reconcile all of these issues, which is that I believe that the question that was initially asked during voir dire, during the group proceeding, was where do you live? And then kind of who do you live with? But based on the answers that were being given by the group, it could have been that the juror thought, where do I live? I live in the Bronx. And that would be consistent with everything that we've heard because he indicated that he had moved out of the Bronx in the last 2 weeks. And there might be some ambiguity about how much time he was spending in each place. But that's at least what he said. As to the second question, he might have understood it to be who is in your family group. As to that question, he indicated his fiance and his baby daughter. And so you can reconcile these things, and given what we're talking about, which is where do you live and kind of basic questions, it would be surprising that someone would try to make up something about that. Maybe even if there was some inconsistency, it wouldn't rise to the level of removal of a juror. So, like I said, they're saying this is minuscule. This doesn't even warrant for this man to be taken off the jury. Okay, that's the issue. And when he's taken off, I do believe that the first alternate that would take his place will be a white male. Okay, an older white male. Okay, so given the various constitutional and other rights that the defendant enjoys. Now, they said the defense expressed concerns about any further inquiry because of the likely negative and intimidating impact that it could have on the juror, especially after the government started suggesting a line of inquiry that could lead to a concern that the juror's employment was somehow in jeopardy in response to because they wanted to reach out and speak to the man's employer. And then basically they were like, that's kind of like now, if you do all of that, now it's like you're harassing the juror. Okay, reaching out to the employer, like that's doing the most, is basically what they were saying. Now that's how I took it. So, in response to the court's comments, the government ultimately stated that the most prudent thing to do to ensure the integrity of the proceedings would be to have additional inquiry. It endorsed further fact finding, stating that such fact finding was necessary to ensure the integrity of the proceedings. The court said that it would consider the parties' arguments and whether to conduct further inquiry later. Now, in light of the discussion in the morning, hold on, beloveds. I scrolled up just a little too quick. Hold on. Now, in light of the discussion in the morning, the defense was stunned when the court announced at the end of the day, in stark contrast to its extensive earlier remarks about why there was an understandable way to reconcile the juror's answers. That it believed the juror was either unable to follow simple instructions and answer simple questions, or was shading the truth or being deceptive, and would dismiss the juror without further inquiry. See, that's what I thought was interesting. Now, all of a sudden, after they said they weren't going to get rid of this man and seemed like they were adamant about it, or the judge seemed to be so, then all of a sudden for the judge to just come out and say flat out that he wants the juror dismissed, and saying that in light of new information that has come out, was it new information that he didn't have in the morning when he said he wasn't going to dismiss the juror? Okay, I have several questions. All right. At the end of the day, and why would they be so quick to jump to the conclusion that this black man has to be a liar? Okay. I just have questions. All right. So, anyway, respectfully, there is simply no evidence to support the court's very serious accusation or its stated concern about the juror's ability to fairly and impartially apply the rules of law of the court to the facts of this case, to consider the evidence in a fair way, and to follow the instructions of the court. Now, the court later stated that when the juror said he had a New York license and still maintained his residence in the Bronx, this was somehow nefarious and suggested an effort to try to get onto the jury. But the juror was already on the jury and had sat through over 4 weeks of trial. having been willing to serve, which many citizens aren't, and having dutifully devoted all of this time to attending the trial. Why would the juror not want to complete this service or his service? Why would he not emphasize that he is still a legal resident of New York, even if he spends several nights a week? And that part is redacted. Now, there is not a shred of evidence that he had a pre existing agenda when responding to voir dire questions, as opposed to a willingness to do his civic duty. And the statements the court cited were made after weeks of service, not the onset. Let me tell you all something, and this is what I want you all to pay attention to, because this is what I have been saying. Whether or not you like Diddy, want Diddy to go to jail or prison or whatever, that's not the point here. The point here is, why is it that when it's a black person, they're so quick? And I want y'all to really listen to what I'm saying here. Why is it that when it's a black person, they're so quick to think that they had some malice, intentions, that they had to be lying or being deceptive? But they did let Brianna Bongalon, who is not black, get up there on that stand and tell whole lies, okay, which were proven to be lies when the defense brought out the receipts, which the prosecution already knew there was receipts to debunk it because they had all of that information during the discovery process. So she was allowed to get up there and give perjurious testimony, okay? And y'all don't find that suspicious. Nobody had anything to say about those lies that she told. But this black man is presumed a liar. Okay? They've not even given him a chance to explain himself. That's the problem that I have with this. Okay? That's the problem. Marie said the judge is biased and made excuses for that. That's exactly what I believe. That's my opinion as well. Now, with that all being said, should the court exclude the juror on the current record? It will no doubt, should the court exclude the juror on the current record, it will no doubt have a chilling effect on minority jurors on their willingness to serve in the future, a step in the wrong direction. The government has previously argued that racial disparities in jury service exist between Black and Hispanic people disproportionately. Okay, they failed to respond to jury qualification questionnaires. And then they reference a case, they cite the case United States versus Slaughter. But the juror answered the call and is dutifully performing what the court stated was a tremendously important task recognized by the Constitution itself. We should invite this service as well as the service of other potential jurors in his community, not discourage it. And here's the thing. I'm just wondering if they made any type of reference to this man being illiterate, because Xavier Donaldson, when he spoke about him, if I'm not mistaken, he said something along the lines of, this man is not illiterate. Like, he can read. Now, I don't know if he was saying that to be facetious or if he was saying that because someone tried to imply that he could not. I just have questions because it's obvious that he could read if he read the questionnaires and filled it out. So what are they trying to say? Were they trying to imply that the man was not intelligent or whatever? I mean, that's what it seems like when they're saying, they're acting as though he can't sit there and take in the information and come to a fair decision based off of logic and the evidence presented. Okay? That's what it seems like. Now, also, they say the government's motion continues a pattern of overreach, suggesting a discriminatory motive in challenging this juror. Although the court denied our Baston challenge and said it found no basis to suggest the government had a discriminatory motive when it sought to strike the juror, we believe that motive is supported not only by its remarkable decision to use 7 of its 9 preemptory strikes on Black jurors. Please pay attention. 7 of their 9 strikes on Black jurors. Do y'all hear this? And don't you find that interesting? Because like I told you, in a country where they've many times had all white juries. Okay, y'all don't think that race absolutely plays a role in these things? Of course it does. Okay, not just with this case, but with many of them. But also by the history of the investigation and prosecution, which has been characterized by extreme government overreach from the beginning. Now, the court accepted the government's proffered reasons for its preemptory strikes of Black jurors as race neutral. Nonetheless, it is important to note that for many of these jurors, the purported reasons themselves were based on the jurors or their relatives' interactions with law enforcement, including prior convictions. But it is well documented that there is a long history of systemic discrimination that has led to mass incarceration of Black and Hispanic people in this country, and of discrimination in how law enforcement treats them in comparison with white people. And that's very true as well. I told you all that there's a marshal in the courtroom that is very rude, speaks to Black people in a very rude and nasty tone, okay, about simple little things, such as telling you you can't chew gum, such as telling you that you can't talk when they're having sidebar, and you're not supposed to talk when they're having sidebar. But there's a way to tell somebody that, because there are in fact many people that talk when there's a sidebar. Okay, but you never hear this officer speak to a white person that way. And I told you all that on Friday I saw him myself sit there and yell at a Black man, okay, about talking during the sidebar. But then a white man pulled out a cell phone and he went over and nicely and politely told him to put his phone away until after he left court. Okay, you're not even supposed to have a phone in the building. Okay, so how did he get a phone in the courtroom? Unless he's an attorney, which I don't know if he is or not, but I was told that only attorneys are allowed to have their cell phones on in the building. Okay, and he was sitting over there with us. So I don't know what he was, but nonetheless, he spoke to him very nicely. Okay, and that's not the first time I've seen that, but let me continue. So now, then, where was I at? Okay, so they talk about they say, moreover, a 2022 study of 3,200 innocent defendants exonerated in the United States since 1989 revealed that Black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. Okay, this is all absolutely true. Absolutely true. And as well, Black people are more likely to be put on death row, wrongly convicted and sentenced to death, only to be exonerated years later through DNA testing. Okay. Citing a prospective juror's former conviction or their relative's former conviction or the fact that they have had negative interactions with the police only reinforces the race discrimination that led to the over-investigation and over-prosecution of Blacks and other minorities in this country. People should not be precluded from serving on juries because of a prior conviction or a relative's prior conviction or the fact that they had a bad experience with the police when the police stopped their car on a pretext or conducted a stop and frisk on a pretext. And let me tell you something. If that's how they want to go by, how they're determining who gets to sit on a jury, we already know that's going to be biased, because who are the ones most likely to have negative interactions with the police, whether you're a criminal or not? We see Black people all the time who are law abiding citizens get pulled over and harassed on the sides of roads during traffic stops. And we also see Black people who are unarmed get taken out on the side of the road at traffic stops. And then the excuse is they were resisting arrest, to which you should all be asking yourselves, if they were resisting arrest, what was the arrest? What was the initial reason for an arrest? If you're pulled over for a traffic citation, okay, where no one was hurt or injured, no crime was committed, and then the police says after deleting you, well, they were resisting arrest. Well, what were they being arrested for? Because they never answered that question. Please pay attention. But let me continue. Now, indeed, if they had a negative experience with the justice system, that is a perspective that is important and useful for a diverse jury. For these reasons, in recent years, courts like the Washington state courts have implemented rules foreclosing the use of a peremptory because a juror has had prior contact with law enforcement officers or has a close relationship with people who have been stopped, arrested, or convicted of a crime. I mean, let's just be real. Almost every Black person in this country knows, either has been, had a negative encounter with the police, or knows someone who has, whether it's a friend, family member, coworker, or whatever. Okay, that's almost every Black person in this country. Not everyone, but many. Okay, probably most. Now, here the government justified several of its strikes on this sort of basis. For instance, it said one reason for the first strike was that the juror had a fiance that served 4 years in prison for a rug with a D conviction. A reason supplied for the second strike was that he had been arrested 3 times, including for harassing a police officer. The fourth strike was a juror whose ex-husband had spent 21 years in prison for attempted murder and remained close with him. and had a brother who had been incarcerated for 2 years based on a rug conviction. The government justified its fifth strike in part on the basis that the juror had two brothers who each did time in prison for felony convictions. Another strike cited inconsistent explanations of interactions with the police. All this proves to me is that they don't trust black people. Okay? Because what does that have to do with you? If someone in your family or someone that you know was arrested, did time in prison or whatever, what does that have to do with you serving on the jury? Are they trying to say that because you know people who have or criminals that you have a soft spot for criminals or that you won't be able to fairly distribute justice? That you're going to be biased? I find it interesting that the justice system in this country is worried about biases when that's exactly what they do and what it is full of, which is biases. But let me continue. Now, history of investigation and prosecution. For starters, it is notable that Mr. Combs, one of the most successful and self made black men in America, and a person who was an icon not just in the black community, but in the music industry, the fashion industry, and otherwise, was indicted by the Southern District of New York Civil Rights Unit. When the unit was established, former U.S. Attorney Damian Williams was quoted as saying, "White supremacist groups are on the march. Anti Semitism is on the march. Anti Asian violence is on the march. Abuse of the most vulnerable in our society is on the march." But this prosecution has nothing to do with civil rights enforcement. What is being prosecuted is allegations about private sexual activity Mr. Combs engaged in with two of his former girlfriends and third parties. You know what I find interesting also? Jimmy Iovine's name was mentioned in Diddy's case. Okay, if you all remember Capricorn Clark, when she got fired from Diddy, didn't she say that when she went to Jimmy Iovine for a job, that he basically told her that she better leave Diddy alone or it's not going to turn out good? Do you all remember me reading that to you? Do you all remember that? And then let's not forget that I also reported to you about a year or so ago that Jimmy Iovine had a lawsuit against him for S assault. Him and many others, but he was one of them. Okay? But I find it interesting that no one really talks about that. That seems to have kind of been swept under the rug. Okay? As along with the story about Peter Nygaard that I was one of the first people to talk about, if not the only person, because I didn't see anybody honestly reporting on that. Okay? And then also Mark Jeffries from Abercrombie and Fitch. Okay? What about Vince McMahon? I mean, I'm just saying, all these other stories just seem to get swept under the rug when it's somebody of my skin tone that's been accused of the same thing. Now, with that all being said, they go on to say that all of Mr. Combs' ventures are entirely legitimate and the government has never suggested otherwise. Instead, the government's case is all about his personal life and his romantic partners, uh, have done what they have done in the privacy of the bedroom. As the trial has shown, the most significant evidence against Mr. Combs involves domestic violence, incidents normally dealt with by local authorities or family courts. Yet the prosecutors have made a federal civil rights case out of how Mr. Combs and his former girlfriends conducted their private lives. Now, the theory of prosecution not only has nothing to do with civil rights enforcement, but it is also unprecedented. Indeed, we are unaware of any other federal criminal case charging racketeering or trafficking based on allegations that a man and his past long-term girlfriends, adult girlfriends, sometimes brought a third party, a male escort or entertainer, into their sexual relationship. Since its inception, the case has been rife with overreach and unusually aggressive tactics normally reserved for prosecutions of violent gangs, organized crime, and terrorism. Do you all hear this? Marie said they're using Diddy as a scapegoat, so we'll forget the other cases. They definitely aren't going to try to remind us of those other cases. They definitely are being quiet about them. And then hold on. Panther Strike said Dana White slapped and punched his wife. Yes, you see how they glossed over that when that all happened? You see how they didn't make a big deal about that? And nor did they make a big deal about that white football player who beat the crap out of his black girlfriend and choked her out and thought she was dead. Remember? And then when she came to, he said, "Oh, I thought you were dead." Do you all remember that? The big, tall, football player with the long hair. I can't remember his name right off top, but I remember reporting on that story, and they kind of just glossed over that as well. So anyway, it goes on to say the purported victims never complained to law enforcement. Ms. Ventura's lawsuit was settled for $20 million, and she never made any complaint to the Southern District of New York or any other law enforcement agency, nor did Jane. Indeed, the government labeled her a victim in, and that part is redacted, and bail arguments long before it had even interviewed her. And she claims to have testified only because she was compelled to by the subpoena. Yeah, I mean, clearly she didn't want to. She only did so because they subpoenaed her, which I also found was interesting. Now, the government has devoted enormous resources to this case. The undersigned are not aware of any other recent cases involving more than 5 AUSAs, and here we have 6 at trial, along with 2 filter team AUSAs and multiple actively involved supervisors. Additionally, the Department of Homeland Security assigned multiple agents to the case, and numerous other agents have assisted at various points, including hundreds of heavily armed agents in combat gear who executed military-style raids, hundreds of heavily armed agents, who executed military-style raids, complete with armored vehicles on Mr. Combs' Los Angeles and Miami homes in March of 2024. And the government also apparently retained a highly paid jury consultant in this case, which is exceedingly rare for the government to do. A consultant who may well be advising the prosecutors in connection with the instant motion. Now, the Southern District of New York refused to engage with the defense counsel during the investigation. Mr. Combs' lawyers approached prosecutors as soon as they learned of the investigation, even before the warrants were executed, and requested an opportunity to meet. Yet the Southern District of New York refused then and repeatedly refused thereafter to engage with counsel substantively throughout the investigation and leading up to Mr. Combs' arrest in September of 2024. The prosecutors also refused to allow Mr. Combs to voluntarily surrender, presumably to create another media spectacle like the one orchestrated during the raids discussed below. Now, the Southern District of New York used misrepresentations and material omissions in warrant applications. Although the court denied our Frank's motion, the defense has documented how the Southern District of New York obtained the March 2024 warrants to search Mr. Combs' homes, person, and all his electronic devices using materially misleading applications. They omitted extensive evidence undercutting the credibility of Ms. Ventura and other witnesses. The warrant applications relied on to establish probable cause. For instance, when obtaining the warrants, the government completely disregarded extensive evidence then in its possession showing Mr. Combs and Ms. Ventura's relationship was, though at times toxic, but it was consensual and loving. The applications also relied on several other witnesses that the prosecutors later admitted were not credible. These witnesses were part of a feeding frenzy of grifters who were trying to extract money from Mr. Combs after Ventura's lawsuit became public. Yet the prosecutors failed to disclose the financial motives of these witnesses and concealed exculpatory evidence that the government had in its possession when it sought the warrants. Are y'all hearing this? This is all news to me, honey. This is all very interesting. Investigators used excessive force and created a media circus during the raids of Combs' homes. The search warrants were executed in a manner calculated to garner press attention, sensationalize the case, falsely portray Mr. Combs as dangerous, and taint any future jury pool. Agents leaked the government's plans to press in evident leaked their plans to press in advance to maximize media coverage and to put on a show. The agents used excessive force against Mr. Combs' children who were in his home doing nothing wrong. One agent held a semi-automatic rifle to the head of Christian Combs, even though he was visibly complying with the agent's demands. Another had a semi-automatic rifle with a laser sight trained and the orange dot visible on the middle of the chest of Justin Combs, who was also complying with agents' instructions. Now, do you see why Misa Hilton was so damn mad? Why she was going off and saying this was all so extra and basically unnecessary? The agents then handcuffed them and paraded them in front of news cameras and a TV helicopter invited by the DHS, who were waiting to get salacious footage of this staged perp walk of 2 innocent young men. Investigators leaked a steady drumbeat of false and prejudicial information to the press until the court issued a broad gag order opposed by the government. Throughout most of 2024, DHS agents repeatedly leaked information about the investigation to the media, including extensive amounts of highly prejudicial and false information about minors, sex dungeons, cameras in the bedroom, and a host of other prejudicial information that has caused online conspiracy theories to multiply. And you see, I told you all about this. You know, you heard it here first. And this is exactly why I told you all. All they're doing, this stuff is going to backfire on them because this is all going to come back to haunt them when it's appeals time. Okay? This is all going to come back on the prosecution when they file an appeal. They're going to use every bit of this information. And even with this motion that they're filing right here, they realize that the likelihood of the judge keeping juror number 6 on the jury is unlikely. And them filing another motion for a mistrial, this will be their third one. Well, that's not going to be granted. But they're doing this, as I told you before, because this is all going to be on the record for when they go and file that appeal. Okay. So with that all being said, likes up everyone, please don't forget to like and share. Thank you in advance. So while this litigation was ongoing, the leaks continued unabated. It was only after the court issued the broad gag order of the defense, or that the defense sought that the leaks finally ceased, long after the jury pool had been deeply tainted. Since then, the government has repeatedly invoked the gag order and local rule 23.1 to prevent the defense, which has a right to try to combat the unfair tsunami of nonstop negative coverage, from any media engagement. At the same time, the government has failed to oppose in any way the numerous apparent violations of that rule by alleged victims and their counsel. Prosecutors insisted on detaining Combs even though he did not present a risk of flight or danger. The prosecutors insisted on detaining Mr. Combs even though he offered to surrender, travel to New York once he learned that he was being charged, and obviously was not a flight risk. They also misled the courts that held the initial detention hearings. For instance, they told the district court of CNN video, told the district court the CNN video refuted Mr. Combs' account of the intercontinental event, that the incident occurred after the couple had an argument over Mr. Combs' relationship and that involved a phone. They said that was just not what happened and just another cover up, just more lies, even though nothing in the trial evidence contradicts the claim that the fight occurred because of jealousy in the relationship. They cited a third victim, Gina, who the prosecutors have entirely dropped from the case. Prosecutors surveilled Combs in jail and invaded the defense camp. The prosecutors next took advantage of Mr. Combs' incarceration to spy on him and invade the defense camp, violating his attorney-client privilege and his First Amendment rights. As the court is aware, shortly after Mr. Combs was detained, a BOP investigator began monitoring his communications. Okay? And BOP stands for Bureau of Prisons. Now, during an allegedly unrelated October 2024 general sweep of MDC Brooklyn for contraband and evidence of corruption, agents completed their search of certain parts of that facility and asked the Southern District of New York whether or not they should continue their efforts and search Mr. Combs' unit. A Southern District of New York supervisor told them to search Mr. Combs' unit because of the government's interest in Mr. Combs specifically, and law enforcement agents proceeded to do so. Now, I want you all to pay attention because you also know that you heard that here first too. Because I told you guys when they said there was a search by multiple agencies going on in MDC, and they said they were looking for contraband, and there had been a myriad of prisoners or inmates that turned up dead in the last few years. I told you all, do y'all think this is a coincidence that they're all of a sudden now doing this while Diddy's there? I said they're absolutely going there to look at what's going on with Diddy, that they're there because of Diddy. And I was absolutely right because it was not a coincidence to me. Okay. Now, with that being said, during the ensuing search, The investigator who had been working with the prosecutors confirmed there was no contraband among Mr. Combs' personal effects, but nonetheless rifled through his possessions and photographed Mr. Combs' notes, reflecting conversations with his attorneys and ideas of defense strategy. The investigator then told a member of the case team about the notes and then turned them over to SDNY. Okay, which tried to use them to oppose a renewed bail application, claiming they showed Mr. Combs was trying to obstruct justice. The court granted a defense application to order the prosecutors on the case team to destroy their copies of the privileged notes. And I want you all to pay attention. Do you hear how thorough this is written up? Do you hear how they're bringing up all these past things that they've already complained about and that they've already filed motions for? They're including that in here with the fact that they want juror number 6 to stay on as a juror, and that if not, they want to file another motion for mistrial. They're including all of that because this is going to be their main piece, I'm pretty sure, that they're going to use for the appeals process. That's why they're including all of these different facts in here, because this is really like a summary of all the BS that they're alleging has gone on. And these are all the same things that I've already pointed out to you, because y'all know I've been keeping track. Okay. Now, with that all being said, they say prosecutors violated Combs' free speech rights. The prosecutors continued their spying and next argued that Mr. Combs' other writings and communications from MDC supposedly involved obstruction, even though these materials were clearly protected by the First and Sixth Amendments. Some reflected his participation in defense efforts to obtain material that could be used to challenge the credibility of the government's witnesses. Other writings describe Mr. Combs' view that the prosecution is racist and his desire to get that message out to counter all the negative media about the case. The SDNY, or Southern District of New York, even went as far as to claim that Mr. Combs' request that his children post a happy birthday message to him on Instagram was an effort to obstruct justice because Mr. Combs hoped it would present him in a more positive light to the public and undo some of the taint to the jury pool caused by all of the negative publicity ginned up by the government and civil plaintiffs' attorneys. All those people that filed those civil lawsuits, basically. Prosecutors abused a filter team to access privileged material. Now, the government's invasion of the attorney client privilege and the defense camp has not been limited to its seizure of Mr. Combs' notes. Throughout the case, Southern District of New York has misused or purported filter team, which was supposed to ensure that the prosecutors handling the case were not exposed to privileged materials on the numerous electronic devices and internet accounts the government has seized and searched. Following execution of the March 2024 warrants, defense counsel provided the prosecutors with the names of attorneys who had presented or represented Mr. Combs and his businesses so that potentially privileged materials could be segregated from the case prosecutors. Now, our understanding was that a filter team would not provide any potentially privileged materials to the case prosecutors without first affording defense counsel the opportunity to review the materials so that counsel could assert privilege if necessary, and so that any privilege disputes could be resolved by the court in camera. Instead, the filter team has repeatedly passed along potentially privileged information without first seeking our input, required us to claw back privileged communications after the case team had already been tainted by exposure to these materials. Prosecutors used the grand jury to help unscrupulous plaintiffs obtain publicity for wildly false claims. Now, after Mr. Combs' arrest, while continuing its investigation, the government publicly paraded witnesses into the grand jury to feed nonsensical media narratives that they knew were false. This created an atmosphere of legitimacy surrounding the many false and wild claims that Mr. Combs and the media circus created by unscrupulous plaintiffs and their lawyers who have encouraged people to file bogus lawsuits against Mr. Combs. You all remember when they got Courtney Burgess with his lying self, the one who lied and said he had 11 flash drives with Kim Porter's memoir on it and videos of freak offs with Justin Bieber and other people that he named. Then he said he had 8. Okay, and he was just all lying. Remember that? They took him before the grand jury. Okay. And I know they knew he was lying because I said he was lying. I knew he was lying when I first heard it. So you think they didn't know he was lying too? Of course they did. Prosecutors attempted to introduce unreliable, decades old, highly inflammatory allegations and used allegations about additional victims who never testified to obtain search warrants, or they used this who never testified to obtain search warrants and seek detention. Now, the government attempted to prop up its case with old, unreliable, and highly prejudicial inflammatory Rule 404B evidence, which much of which the court correctly and fortunately excluded in granting the defense's motion in limine. And although the court denied the motion to exclude the testimony of one alleged victim, another girlfriend who had no interactions with any of Mr. Combs' employees or the alleged RICO enterprise, that individual apparently has decided not to testify. Likewise, the government spent over a year claiming that Mr. Combs' former girlfriend Gina was a victim and used that allegation to support arguments for bail and to obtain warrants and presumably in the grand jury, even though blank and blank, that's redacted, and the government did not call her as a witness. Despite including her in the indictment, the government has not elicited any evidence at trial that could possibly support the conclusion that she is a victim. Prosecutors have engaged in other misconduct during trial. We recognize that the court has denied our two mistrial motions, but as the court is aware, we believe the government asked inflammatory and highly prejudicial questions of Inspector Jimenez to try to suggest Mr. Combs had somehow orchestrated the destruction of fingerprint evidence in 2012 and then presented testimony from Cassie Ventura and Brianna Bongalon that it knew or should have known was materially false. Now, the government's history of these extremely aggressive tactics in this case is critical context against which it attempts to remove the juror and must be evaluated. In this case, the prosecutors have repeatedly flouted their office's self proclaimed tradition of doing the right thing the right way for the right reasons. Their pretextual motion to dismiss this juror is just one more attempt to gain an unfair advantage at the expense of Mr. Combs' right to a fair trial, which is all we ask this court to preserve. For the foregoing reasons, the court should allow this juror to remain on the jury. If the court truly believes his statements raise serious concerns about his ability to follow instructions, which we respectfully submit would be an unfair and unsupported conclusion based on what were at worst imprecise answers to the court's questions, then in fairness, this is all redacted. And then, if the court dismisses the juror, the unfair prejudice from replacing him with the first alternate at this late stage of the proceeding warrants a mistrial. Respectfully submitted. This is signed by all of the attorneys Alexandra Shapiro, Jason A. Driscoll, Mark Agnifilo, Tini Garagos, Anna Estavo, Brian Steele, okay? Xavier R. Donaldson and Nicole Westmoreland. Okay, so y'all heard that? Y'all heard that? So what do you guys think? What do you all think? I find it all interesting, you know? Um, hold on. Kay Wood said, I called it. I put in for a mistrial for racial. You did, beloved? All right, Kay Wood. Well, thank you for your insight into the topic, beloved, and for your contribution to the channel. Peace, love, and blessings. Okay. Mel said, yes, Queen, he was a liar. Okay. Are you talking about the juror? Well, we don't know if he was a liar or not. We don't know if he was a liar or not, beloved. So let's not jump to conclusions. I'm not going to call that black man a liar because I don't know if he lied or not. Somebody said that he told them something, and they could be a liar for all you know, because I want to know if they have any proof of this. Okay? Until then, it's just hearsay as far as I'm concerned. And this ain't about Diddy. This is about the juror. Because I don't like the fact that they're just trying to assume that this black man was doing something nefarious. Okay, Red Aries says that's a violation of attorney-client privilege. A mess. And this whole case is a mess at this point. Nellie Love said if he gets a mistrial, he has to stay in jail, correct? I keep hearing that's what will happen. Well, here's the thing. He's not going to get a mistrial. That's for number one. They're filing this, like I said. I very seriously doubt he's going to get a mistrial. They're filing this so that it's just on the record for when they file for the appeal. But of course, if you get a mistrial, then they have to determine whether or not they're going to retry you. And in Diddy's case, if he were to get a mistrial, of course they're going to retry him. Okay. JC Talks Trial said, wow, thank you for this read, Queen. You're welcome, beloved. Thank you for tuning in. Okay. Now, with that all being said, I'm about to be out of here, you guys. Bree says, Queen, do you think that the juror had started looking at coverage of the trial since they told him not to come back? No, because here's the thing. They didn't tell him not to come back. They didn't tell him not to come back. I don't think they've told him yet, beloved. They just said all of this on Friday, and they said it right after the jurors were dismissed for the day. Okay, they said this after he left for the day. When they left, they told the jurors goodbye for the day, and we'll see you on Monday. So this man didn't know anything about he was being dismissed, honey. I don't know if they sent him a letter, called him, or whatever as of yet, but as of Friday, he didn't know anything about this because they said all of this after the jury was released for the day. Okay, we were the ones still sitting in there. Those of us who were still in court, we heard all of this, but the jury was already gone for the day. They've been dismissed. So with that all being said, Nelly says, thank you. You're welcome, beloved. So this is all crazy at the end of the day. JC Talks Trial says he will then go back for bail and it will be up to the judge for bail. Yep. And we know they don't want to give Diddy bail because they sure didn't want to give it to him last time, which I found interesting because they sure gave Michael Jeffries bail. Okay. And what was Michael Jeffries doing? Okay. Messing with those young men. And they said that he wasn't a threat though because of his age. He might be older than Diddy, but he had a whole lot of money, and he also had access to private planes and all of that. So I don't see why he was less of a flight risk than Diddy. Okay, I just found that very interesting, and his charges were equally as nefarious as far as I'm concerned. Okay, so that all being said, I hope you all got something out of this. I will see you all in the morning, bright and early, because I will be at the courthouse. Okay, so you all tune in. With that being said, everyone enjoy the rest of this evening. Again, happy Father's Day to all of the fathers. And I love you all to life. Each one teach one. That's how we grow and thrive. Do something productive, constructive, but never destructive. And always remember, beloveds, to keep the Most High first in your lives. Until next time, beloveds, I will talk to you all again soon. Peace.
Gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you're done. They show no love for the queen. Why you hating on me? Is it cause I'm free and I got Malcolm X in my jeans? I got dreams like King Luther, shed blood like Kunta. You ain't helping my people, I ain't got nothing to say to ya. I want all the smoke like hookah. Talking reparations, America won't be great until they give us compensation. I'm like, I'm the hottest right now. See a bunch of lames out here trying to jock on my style. They be doing too much. I'm the queen, it's too easy. It's like they all at Popeyes, how they be talking so greasy. I just sit back and laugh while these haters get madder. So nefarious how they don't want my pockets with cheddar. I tell them they can do better. These snakes in the grass can leave a bite on your ass, cause y'all be trusting too fast. I got my foot on the gas, other one on they necks. Dropping receipts on haters, you better show some respect. I'm never facing regrets, we only facing the threats. Running through every challenge like a relay, break no sweat. It's a cold game, so I got that blanket with me. Now that my people awaken, ain't no going to sleep. I do not play by my piece, this time I'm playing for keeps. You talking slick, but when I see you like them ends, we gon' meet. And I got gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you done. They show no love for the queen. Why they hating on me? Is it cause I'm free and I got Malcolm X in my jeans and I got gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you done. They show no love for the queen. Why they hating on me? Is it cause I'm free and I got Malcolm X in my jeans and I got